Good afternoon. Welcome to my YouTube channel. My name is David Okun, and I'm talking about pay in the UK as in work, what people do, and the money they pay. Today we will be talking about the national minimum and the national living wage, like we said before, and we continue with the process. And thank you so much for coming. Thank you for subscribing and clicking notification bell, leaving comments, sharing the video with family and friends. And I'm so grateful that you came today. So let us look to the information regarding pay, national minimum wage and the living wage, which applies in England, and also in other cases it may apply to Northern Ireland and also Scotland. Thank you so much, and we are going to look at how the minimum wage legislation was introduced, if introducing, also looking at the national minimum wage and people who are not entitled to the national minimum wage, who is entitled and who is not entitled to the national minimum wage, and which works, hours does the minimum wage applies to, and the pay reference period, how much is the national minimum wage, how to calculate the workers' current hourly pay, to compare it to the national minimum wage, and also what shouldn't be included when working out the national minimum wage pay. This is legal, also statutorily based information. So therefore, what should be included when working out the national minimum wage pay, payments for accommodation and childcare vouchers, and the national minimum wage, and our overtime or premium rates of pay are treated if the employer provide meals, tips, and gratuities, information about the national minimum wage for workers, the employer's duty to keep records about the national minimum wage, the workers' rights to access to record about the national minimum wage. Can a worker agree to be paid less than the national minimum wage? How can a worker make the employer pay the national minimum wage? And employees who wants to make a national minimum wage claim to unemployment tribunal, also we are looking at that. Employees, and also the right not to be dismissed or suffer detriment because of the national minimum wage. So look at the role of the enforcement agencies and the national minimum wage compliance officers. Stay tuned, continue watching. Thank you so much. We're going to look at naming employers who do not pay the national minimum wage and common problems with the national minimum wage organizations which can help with the national minimum wage, and the other information regarding calculating the national minimum wage pay, and also examples of calculation to compare the workers' pay to the national minimum wage. And so let's look at the introduction of national minimum wage legislation, which is law in the United Kingdom. If you live in the United Kingdom, if you live outside the United Kingdom, this information necessarily applies in the UK, but because of globalization, like I said previously, what happens in the United Kingdom also applies outside the United Kingdom. So stay tuned, pay attention, be your own master or mistress by learning the things like national minimum wage in the United Kingdom. And if you live in another country, you can find out what happens in your country, and whether you get paid national minimum wage or whether you get paid something else in an equivalence, and the logic following from there. Following the passage of the National Minimum Wage Act in 1998, the National Minimum Wage NMW came into force on the 1st of April 1999. From this date, most workers in the United Kingdom aged 18 or over became entitled by law to a national minimum hourly wage regardless of where they work, the size of the firm, or the worker's occupation. The national minimum wage was extended to workers aged 16 and 17 from October 2004. Regulations had already brought in some parts of the acts on the 1st November 1998, including the setting up of the Low Pay Commission. In addition, from this date, workers are protected if their employer tries to dismiss them or treat them detrimentally because they qualify for the national minimum wage. From the 6th of April 2015, the National Minimum Wage Regulations 2015 enacted and consolidated previous national minimum wage regulations. So the national minimum wage is fixed at different rates for certain groups of workers depending on age or on participation in an accredited training scheme or a work scheme which is funded by the government or the European Social Fund. The national minimum wage is set in line with recommendations from the Low Pay Commission, which reviews its level periodically. The national minimum the national minimum wage age bands are specifically excluded from the scope of the Equality Act 2010 and therefore are not classed as discrimination on the grounds of age. So more about the age discrimination. Stay tuned, continue watching, leave a comment below, let me know what you think about this law on pay in the United Kingdom. So it is important to note that all money payments made to a worker count toward pay to be compared to the national minimum wage, except explain certain specific payments. For example, basic pay includes income tax and national insurance contributions, productivity bonuses, profit-related pay, and other forms of performance or incentive pay. These will therefore all be taken into account when calculating pay to be compared to the national minimum wage. We are also looking at a national living wage. As part of this program, on the 1st of April 2016, the national living wage took effect. It worked in the same way as the existing national minimum wage. Everyone eligible should be paid the national living wage for all work done from the 1st April 2016. This means everyone 25 or over who is already eligible for national minimum wage. From the 1st of April 2024, everyone 21 or over is eligible for the national living wage. Leave a comment below, stay tuned, continue watching. If someone isn't paid enough, follow the same process as for the national minimum wage, starting with calling the ACAS helpline. Unfair treatment because of the national living wage. So let's look when employers cannot fire people or after their work or alter their work to get around the national living wage. This works in the same way as the right not to be dismissed or suffer detriment because of the national minimum wage. Changes that can be challenged include challenging contract terms, withdrawing work from agency workers or people on 0-hour contracts, moving to people under 21 who is entitled to national minimum wage. All workers, except those in certain specified groups, are entitled to the national minimum wage. This includes all employees, that is, workers who work under a contract of employment. That is, workers who work under a contract of employment move about how to check if someone is an employee. Casual workers, part-time workers, workers on short-term contracts, and workers employed by subcontractors. Agency workers, home workers, peace workers, more about how to check if someone is a worker. Stay tuned, continue watching. So we'll continue with the national minimum and the national living wage in the United Kingdom. We also look at home workers like we did, and peace workers, and also if you're interested to know more, you can find out online about how to check if someone is a worker. From the 1st of April 2024, people living and working with a family, including au pairs, nannies and companions, certain self-employed workers, people from overseas working in the United Kingdom, regardless of whether they work for UK or an overseas firm, who do not fall into an exempt group. From June 2016, those who qualify include posted workers in the construction industry, UK workers temporarily working abroad. The Act does not define temporary, but says that a worker who ordinarily works in the United Kingdom but is temporarily working abroad is covered by the national minimum wage. Mariners who work on board UK registered ships, unless they work entirely outside the UK or do not ordinarily work in the United Kingdom. Offshore workers who are working in the UK territorial waters or in the UK sector of the continental shelf, for example, people working on oil rigs. These workers will qualify regardless of whether or not the employer is based in the United Kingdom. Looking at apprentices age 19 or over, certain people carrying out therapeutic work. This is work-related activity undertaken by an individual who has problems functioning in the normal labor market, for which they are paid and may also be receiving state benefits. There is a guidance about who counts as a worker for the national minimum wage if they are undertaking therapeutic work on the gov.uk website, www.gov.uk. So looking at agricultural workers as well, agricultural workers may be entitled to an agricultural minimum wage. Where the national minimum wage is lower than the agricultural minimum wage, the higher the rate will apply. There are special rules for agricultural workers. More about agricultural workers, special rules for agency workers. Most agency workers are included in the definition of worker for the purposes of the national minimum wage and are therefore entitled to receive the national minimum wage. For example, a temporary office worker referred through an employment bureau would be covered regardless of whether they are paid by the agency or the employer. Generally, self-employed people who get work through an agency are entitled to the national minimum wage. These will include self-employed people put in contact with the potential employers through other introductory agencies. For example, a minicab driver who is introduced to potential customers by an agency to whom they have been they have paid a fee would not be covered. More about the employment rights of agency workers, more also about how to check if someone is an employee or self-employed. Stay tuned, continue watching. So look at special rules for home workers. Most home workers will be covered by the national minimum wage. This includes home workers who do not carry out all or some of their work personally because they are assisted by others, for example, family members. Many home workers do output work. The rules on the national minimum wage for output workers apply to home workers who does output work. People who work at home but are genuinely self-employed are not covered. More about checking if someone is an employee or self-employed. Stay tuned, continue watching. Look at special rules for self-employed people. If an individual does not have a contract of employment with an employer but works personally only for the employer, they will be covered by the national minimum wage. An example of people who are self-employed but are likely to be covered by the national minimum wage include casual workers, building subcontractors, and waiting staff hired for functions. If they are running a business, they will not be entitled to the national minimum wage. More about how to check if someone is an employee or self-employed. Special rules for agricultural workers in England and Wales. Stay tuned, continue watching. From the 25th of April of June 2023, the Agricultural Wages Board for England and Wales is abolished. The current agricultural wage order, which covers agricultural workers, runs until the 1st of October 2023. How this will affect the worker depends on whether the worker started work for their employer before the 1st October 2013, or the worker started working for their employer before the 1st October 2013 but is dismissed on or after the 1st October 2013 and is reinstated with a new contract of employment, or the worker started working for their employer on or after the 1st of October 2013, the worker is employed in Wales. The abolition of the board affects agricultural workers who started working for their employer before the 1st of October in 2013 in England only. So an agricultural worker who started working for their employer before the 1st of October 2013 is covered by the agricultural wages order until 30th September 2013, when that order runs out. It will not be replaced by a new agricultural wages order from the 1st of October 2013. Therefore, until the 30th of September 2013, agricultural workers will remain entitled to the minimum wage for agricultural workers as set out by the agricultural wages orders, in addition to the special rules about their entitlement to holiday pay, sick pay, and limits on working time. And from the 1st of October 2013, the wording of an agricultural workers' contract of employment will determine whether they continue to be entitled to work under the same terms and conditions in relation to holiday pay, sick pay, and limits on working time, and to be paid an hourly rate the same as the minimum wage that they were paid under the agricultural wages order. So the workers' contracts may be unclear or silent about these terms and conditions or rates of pay, or may say that they are entitled only to the minimum statutory entitlements and statutory minimum wage. This is, if this is the case, the employer could argue this means that when the agricultural wages order runs out on the 1st of October 2013, the workers' terms and conditions will change to ordinary minimum statutory levels, and their hourly rate pay will reduce to the ordinary national minimum wage level. However, the worker could argue that their existing terms and conditions and rate of pay under the national minimum wages order become implied terms of their contract, and that if the employer tries to change the terms and conditions or reduce their pay to the level of the ordinary minimum wage, this amounts to a breach of contract and or an unlawful deduction from wages. If it is a serious breach, the worker provided an employee and has worked for the qualifying period, this would be entitled to resign in response and claim an unfair constructive dismissal. If you are interested in knowing what takes place more, you can actually go online and look and more about causes of actions if an employer cuts an employee's pay. And we are talking about pay. Stay tuned, continue watching. So we'll continue. So if the contract contains terms and conditions expressed as a specific number of hours, days or weeks, then the employer is likely to have to leave unchanged these terms and conditions. If an entitlement to an hourly rate or pay equivalent to that set by the agricultural wages order is expressed in the contract as a monetary sum. For example, the contract says the worker will be paid £6.96 per hour. Then the employer should continue to pay that rate under the contract. This should continue to be the case until the ordinary minimum wage rises to the same level as the wage under the Agricultural Wages Order. If you're interested to know more about agricultural workers and how they are paid, you can look online at .gov.uk. Stay tuned, continue watching. So if the employer dismisses the employee and puts them on a new contract with less pay in England only, an agricultural worker who started working for their employer before the 1st October 2013 may be dismissed and reinstated with a new contract to avoid continuing to pay them the higher levels of pay. If an employer does this, this will be a breach of contract unless there is a variation term in the employee's contract allowing it, or the employee agrees to the change. If the employee does not agree to the change, they should try to negotiate first with their employer before starting any legal proceedings. It is always important to act reasonably, particularly if it is later necessary to bring a claim for unfair dismissal. The possible legal remedies for a cut in pay are make a claim to an employment tribunal for an unauthorized deduction from wages, which could result in the original wage being restored, or sue for damages in the county court. Or if the worker has left work, claim breach of contract at an employment tribunal. If the worker is an employee and has worked for the qualifying period, leave the job and claim unfair constructive dismissal at an employment tribunal. You can look more on courses of action if an employer cuts an employee's pay. And the abolition of the board affects agricultural workers who started work for an employer on or after the 1st of October 2013, this applying only in England. An agricultural worker who start working for their employer on or after the 1st of October 2013 will not be able to rely on the Agricultural Wages Order for their pay, holiday pay, and sick pay. They are entitled to the national minimum wage and the statutory rights to sick pay, holiday pay, and working time in the same way as other workers, unless their contract gives them additional rights. Legal comment below. Let me know what you think about this kind of policy. You can find out more about rights to holiday and holiday pay, also about rights to statutory sick pay, and also rights to limits to working time. So how the abolition of the Agricultural Wages Board affects agricultural workers in Wales. Stay tuned, continue watching. In Wales, agricultural workers will continue to be entitled to work under the same terms and conditions in relation to holiday pay, sick pay, and limits on working time as they were under the agricultural orders, wages orders, and be paid the minimum wage and be paid the same, the minimum wage they were entitled to under the Agricultural Wages Order or the national minimum wage rate if that is higher. For a copy of the leaflet introduction of the national minimum wage in the agricultural and horticultural sectors in England and Wales, you can actually look for this online. And workers in Wales were concerned that they are not receiving the correct terms and conditions can contact the Welsh Government Sustainable Land Management Branch. The contact details are Welsh Government Sustainable Land Management Branch, Rodfa, Padam. These are the details you find online if you are interested in some specifics. So government guidance on agricultural workers in workers' rights in England. The Department for Environment, Food and Rural Affairs, DEFRA, has produced guidance on the rights of agricultural workers in England. This is available on the gov.uk website at www.gov.uk. Guidance on the changes from 1st October 2013 is in the last section of this guidance. There is also a more detailed booklet on these changes. Stay tuned, continue watching. For a copy of the leaflet introduction of the national minimum wage in the agricultural and the horticultural sectors in England and Wales, you can visit the relevant website, and you will find them readily. People who are not entitled to the national minimum wage. The following groups are not entitled to the national minimum wage: people of age below compulsory school leaving age. For example, these are actually children, perhaps if they are below, normally they are below 15, and so if they are genuinely self-employed, or more about how to check if someone is self-employed. So let us also see to consider those serving members of the armed forces. This does not include civilians in an association of reservists or civil employees of the Ministry of Defense. And also let us look at share fishermen, prisoners in custody, including those on remand from any work they are required to do under prison rules. Office holders, for example, a company director who is not also an employee of the company, or a member of the clergy if they don't have a contract of employment. Most voluntary workers, and therefore some trainees on government-funded or European Social Fund are funded schemes, and some people on work experience schemes. And from the 1st of October 2009, workers on the European Community, Erasmus, and Comenius programs, workers are taking part in a scheme run by a non-profit making charity which only provides work for homeless people. This applies if immediately before taking part the worker was homeless or living in a hostel or homeless people and was entitled to income support, universal credit, income-based job seekers allowance, or income-related employment support allowance, or was not entitled to any of this benefit only because they were not habitually resident in the United Kingdom. More about habitual residents, welfare benefit and tax credit, and book online. You can find this information there. And residential members of religious communities, provided that the community in which they live is a charity but not an independent school, and that the purpose of the community is to practice religious belief, and all or some of the members live together for that purpose. These are some of the details contained in the program in relation to pay, particularly minimum and living wages, and also other aspects of pay. the national minimum wage is not payable when jobs are done under informal arrangements between people. This includes, for example, someone who helps out a neighbor by doing shopping or receives token payment. Special rules for apprentices. Leave a comment below if you know anything about apprentices. We have discussed this previously. A person will be treated as an apprentice if they are a worker who has a contract of apprenticeship. This includes someone with a traditional contract of apprenticeship, or they are a worker and are taking part in a particular government training scheme. These schemes are in England: apprenticeships, advanced apprenticeships, intermediate level apprenticeships, advanced level apprenticeship, or trailblazer apprenticeship in Wales, foundation apprenticeships, or higher apprenticeship in Scotland, modern apprenticeship leading to a Scottish vocational qualification at level 2-3 or NVQ at level 2-3. Leave a comment below if you know these aspects of working learning program in the United Kingdom. A worker is defined as someone working under a contract of employment or someone working under a contract to provide a service personally while they are not self-employed. Remember discussing previously the difference between contract and statute in terms of right of employment. Rules for apprenticeship from 1st October 2010. From the 1st of October 2010, an apprentice who is age under 19 will be entitled to the new apprentice rate of national minimum wage. However, there are special rules for apprentices in England who are being paid a minimum amount of £95 per week before the 1st October 2010. Remember, we also discussed the problem to do with low pay in the United Kingdom, also politically, and also in terms of welfare, keeping the British people perhaps also willfully or inadvertently in poverty. So we're looking at people aged 19 or over who will be entitled to the new apprentice rate of national minimum wage in the first year of their apprenticeship. After that, they are entitled to the normal rate of minimum wage for their age if they continue their apprenticeship with the same employer. If they move to another employer after the first year, they will only be entitled to the apprenticeship rate. Before the 1st of October 2010, an apprentice who is age 18 or under does not qualify for the national minimum wage until they reach the age of 19 in England and Wales, until and Scotland also. From the 1st of October 2009, an apprentice age 18 or under should be paid a wage of no less than £95 per week and must be offered a minimum of 16 hours work per week. Though most apprentices work full-time, they are not entitled to the 16 to 17 or 18 to 21 rate of minimum wage because they are an apprentice, not a worker. Once they reach the age of 19, they may become entitled to the minimum wage. Age 19 or over does not qualify for the national minimum wage for the first 12 months of their apprenticeship in England, Wales, and Scotland. From 1st of August 2009, during these 12 months, they should receive a minimum of £95 per week once they have worked for their employer for 12 months as an apprentice, provided they have reached an age of 19 years. 19 during the 12 months, they will become entitled to the normal minimum wage after their age, provided they are still working for their employer. This means that if someone age 18 and a half starts an apprenticeship, they will not be entitled to the minimum wage until they are age 19 and a half, so that they have worked for their employer as an apprentice for 12 months. A person age 19 or over who is no longer an apprentice but is a worker will be entitled to the normal rate of minimum wage for their age. The Employment Appeal Tribunal has held that stay tuned, continue watching. So the Employment Appeal Tribunal held that in deciding whether or not someone fell within this exemption to the national minimum wage, their position in the family must have been considered holistically. That is, the whole arrangement and the nature of the relationship of the worker with the family must have been taken into account. It should also consider the general dignity with which a domestic worker was treated, the degree of privacy and autonomy they were afforded, the extent to which, if at all, they were exploited. The exemption didn't require the worker to share all meals and also the task and leisure activity with the family, but that the worker was treated as a member of the family in this respect. So stay tuned, continue watching. And special rules for voluntary workers. We're talking about volunteers in the United Kingdom. The voluntary workers are not covered by the national minimum wage because in law they do not have contracts of employment. However, the voluntary workers who receive some remuneration for their work may be covered. Voluntary workers who receive only the following forms of remuneration are not covered by the national minimum wage. Subsistence payment to a voluntary worker placed by a charity with either another charity, voluntary organization, or association, fundraising body. These workers would include, for example, voluntary workers placed by a voluntary bureau with schools or hospitals. Also, actual or reasonably estimated payments in respect of expenses incurred in their work, including travel expenses. Also, benefits in kind, for example, meals or accommodation. Special rules for trainees and people on work experience and government training schemes. Stay tuned, continue watching. Trainees who receive remuneration from their employers rather than state benefits are entitled to the national minimum wage because they count as workers. Remuneration does not include reimbursement of expenses incurred in performing work. However, if a trainee does not receive wages from their employer and is in one of the groups in the next paragraph, they are not entitled to the national minimum wage. Workers who are participating in one of the following schemes do not qualify for the national minimum wage in respect of work done for their employer as part of the scheme. In England, entry to employment or program late apprenticeship in England from the 7th of March 2014, trainees on skills programs are lasting a maximum of 6 months, which are aimed at young people aged 16 to 23 without the skills or work experience needed to get a sustainable job. This will be extended to include 24-year-olds from 2015 and 2014 and 15 in Wales, foundation apprenticeships or traineeships in Scotland. And stay tuned, continue watching. In Ireland, access also the following groups of trainees are not entitled to the national minimum wage unless they receive wages from their employer in England and Wales. Trainees on the following government-funded schemes based work-based learning for adults, national traineeships up to NVQ level 2, youth training and work trainee trial schemes in Scotland. Trainees on the following government-funded scheme training for work and skills seekers who are not pursuing modern apprenticeship in England. In Northern Ireland, trainees on the following government-funded scheme training for success, NVQ level 2 and modern apprenticeships in Northern Ireland from September 2001. Stay tuned, continue watching, and leave a comment below. Let me know if this amount to the distortion of pay in the United Kingdom, where when people do some work, one work or another. And if you ask me, this is actually a scheme which is may or may not be good at all in terms of pay. It may help in other ways, but you know, if you are keen on paying people who work, if you do any kind of work, you should be paid within contract or without the statutory requirement. But the most important for me is actually the level of pay, whether contractually or statutorily achieved. So look at apprenticeship also on trainees on job plus work trials, which are of not more than 6 weeks. Trainees on European Social Fund funded schemes unless they have a contract or employment with their employer. Students on sandwich courses and trainee teachers, undergraduate or postgraduate students on higher education courses at university or college who are placed with an employer for up to 1 year as part of their course of study are not really entitled to the national minimum wage for the work experience part of the course. Students in further education who attain a period of work experience as part of their course are not entitled to the national minimum wage. This is a form of slavery, modern day slavery in the United Kingdom, in my opinion. Leave a comment below. Let me know if you work for an industry or otherwise. You should be paid whether you're a student or not, and this is unacceptable in my opinion. Stay tuned, continue watching, leave a comment below, let me know what you think. Which work hours does the national minimum wage applies to? Stay tuned, continue watching. Thank you so much. If you haven't subscribed to this channel, subscribe. If you haven't, thank you if you have subscribed, share. If you have watched and shared, and also if you're watching, share with family and friends, as well as leaving a comment below. Let me know your thought before you can calculate a client's entitlement to the national minimum wage. You will need to find out how many of the hours which they spend at work actually count towards their working time. This is because the national minimum wage is an average hourly rate which must be paid for each hour worked in a pay reference period. Stay tuned, continue watching, and thank you so much for your participation in this program. The national minimum wage regulations specify which hours can be counted as part of the working time for the national minimum wage and which cannot, and which ones cannot. For the purposes of calculating hours worked, part of hours are counted as full hours. Stay tuned, continue watching. Thank you so much. The regulations define the regulation define 4 different types of working time, of which all of which qualify for the national minimum wage. Salaried hours worked. This is work which is paid for on the basis of an annual salary paid in equal installments. For example, 12 monthly installments or 52 weekly in installments. Time work. This is work which is paid for according to set or varying hours or perhaps or periods of time for example, £5 per hour multiplied by the number of hours the worker works in a week, and most workers will be time workers if they are not on an annual salary. Stay tuned, continue watching, leave a comment below, let me know your thought on this kind of scenarios, state of affairs, the output work. This is work which is paid for entirely by reference to the number of pieces of the number of pieces the worker makes or processes or some other measure of performance such as sales targets met. Stay tuned, continue watching, let me know what you think about pay in the United Kingdom and measured hours work. This is work which does not fall into any of the above group but still counts as work towards the national minimum wage. It includes jobs which specify particular tasks which must be done but not particular hours of work. For example, a warden at a youth hostel or a live-in pub manager. Stay tuned, continue watching. Some workers carry out a combination of the above types of work, for example, where they are paid a basic salary which can be increased depending on the number of sales made. These hours are counted differently depending on the type of work being done at the time. Stay tuned, continue watching. Let us look at salaries hours work as well. And stay tuned, continue watching. Thank you so much. Stay tuned, continue watching. So salary hours work is work which is paid for on the basis of an annual salary paid in equal installments. For example, 12 monthly installments or 52 weeks installments. Variation in the weekly or monthly installments do not stop the work being salaried or hours salary hours worked. For example, if the worker receives a pay increase or performance bonus or an overtime payment, provided the worker still receives an annual salary in installments, they will be a salaried hours worker. Stay tuned, continue watching. Workers who are likely to be salaried hours workers include office workers, workers in large companies, and workers in public sector organizations. Workers who work for only part of the year but receive salary installments all year around. For example, school caretakers are also likely to be salaried hours workers. There are so many different types of payment systems which are so complicated, and only God in heaven will know the basis of that complexity. If you are trying to pay someone working for a living, it should be simplified, and it is a form of insanity, policy insanity in my opinion. Governments and employer colliding or colluding, whatever you want to call it, to create this kind of monstrosity. Stay tuned, continue watching, leave a comment below, let me know your thoughts. So salary hours work include all time spent at the workplace, except in the examples below. It includes time spent on call, where the worker has to be available at or near the workplace even though they are not actually working. There are special rules if there is provision for the worker to sleep at the workplace. If the worker is on standby or on call at home, those hours spent at home do not count towards their hours of work. Stay tuned, continue watching, leave a comment below about this situation. I think it's theft and brutality by a modern type of state and their fellow emperors in the working industry. Stay tuned, continue watching. Time spent traveling in connection with work, unless the traveling is incidental to the nature of the work. Time spent traveling because of the worker's duties are carried out while they are traveling. For example, serving in a bar or a train counts as salary hours work. Salary hours work does not include time spent traveling from home to work or from work to home. It does, however, include time spent traveling to different work sites, for example, to attend meetings or make deliveries. There are examples of how time spent traveling in connection with work is calculated for the national minimum wage. You see, the problem with this kind of working structure, if the company is not busy, you are unemployed. You work, but you don't work. So stay tuned, continue watching. Leave a comment below. Let me know what you think. So let us look at time in terms of minimum wage, time spent on training courses. Unlike the situation of time work, hours of absence from work, for example, maternity leave, sick leave, holiday, rest, and lunch breaks do not count as salary hours work. However, if the hours of absence are paid at a lower rate than normal, they are not counted. Stay tuned, continue watching. Just pay attention to the complexity of this material in terms of pay. If people work for a living in a just and fair society, you don't make it complicated, you simplify it. This is a form of legalized form of corruption by employer and their bad governments. Stay tuned, continue watching, leave a comment below, let me know what you think. So we'll look at salary hours work, which does not include the following: whether the activity takes place at the workplace or not, time spent engaged in industrial action. These include strikes, go slows, and working to rule a special a period where the worker is paid less than their normal pay. For example, if they are not long-term sick leave, if they are on long-term sick leave, this period of absence does not count as salaried hours work. So this complicating of pay structure is aimed at one thing: avoiding the minimum wage and the living wage payment, which is already low, too low for a developed country and a rich country like Britain. I've talked a lot about this before in the other videos. So we're looking at a long period of unpaid leave, which is allowed. For example, if a worker takes 6 or 12 months sabbatical leave, then this time does not count as salary hours work. Flexi time, time off in lieu, toil, which is quite telling. This is an acronym, toil. If you comment below, let me know. Time in lieu, time off in lieu, time off in lieu, toil. That is the acronym, time off in lieu, flexi time. So many salary hours workers are entitled under their contracts to work flexi time or take time off in lieu of extra hours worked. If they take time off as flexi time or toil, these hours away from work do not count for the purposes of the national minimum wage. And in what sounds as an option can be mandated by a mightily powerful employer, which is something we need to really pay attention to. This is because the weekly hours worked are the same as usual, but have simply been spread over a different number of days. Time work. So time work is work which is paid for according to set or varying hours or periods of time. For example, £5 per hour multiplied by the number of hours the worker works in a week. Most workers will be time workers if they are not on an annual salary. If the worker receives an annual salary, their work will count as salary for hours worked. If you comment below, let me know what you're thinking. So time work includes all time spent at the workplace except in certain circumstances. So time work includes the time spent on call, when the worker has to be available at or near the workplace even though they are not actually working. There are special rules if there is provision for the worker to sleep at the workplace. Time spent traveling in connection with work, unless the traveling is incidental to the nature of work of the work. Time spent traveling because the worker's duties are carried out while they are traveling. For example, serving in a bar or a train counts as time work. The time work does not include time spent traveling from home to work or from work to home. It does, however, include time spent traveling between different work sites, for example, to attend meetings or make deliveries. And then there is no peace for the wicked, because you are always working even if you are not working, and you are paid and you are not paid. There are examples of our time spent traveling in connection with work is calculated for the national minimum wage, time spent on training courses if certain conditions are met. Stay tuned, continue watching. So time work does not include the following: whether the activity takes place at the workplace or not, time spent engaged in industrial action. These include strikes, go-slows, and working to rule. Time spent on agreed rest breaks include lunch breaks, whether or not they are paid. Other time spent absent from work, for example, if the worker is on holiday, off sick, on maternity leave, or other leave as provided for under their contract, once the average hourly rate of pay has been calculated, taking into account which hours count as time work, it is compared to the hourly rate of the national minimum wage to which the worker is entitled, to see if the worker is being paid enough. Our time spent traveling on business is calculated for the minimum wage. For salary hours worked, and time worked. Stay tuned, continue watching. Time spent traveling between home and someone's normal place of work and back again does not count as time when the national minimum wage is payable. Stay tuned, continue watching. However, there are some periods of traveling time connected with work which are not when they are traveling between home and their normal place of work and when the national minimum wage must be paid to a time or salaried hours worker. These include time when the worker is required to travel in connection with their work other than traveling between home and work. Any other rest breaks taken during the time the worker is traveling count as time worked. For example, lunch on board a train. Stay tuned, continue watching. Waiting for a train or changing trains or other form of transport except during rest breaks, traveling from one work assignment to another except for rest breaks, waiting for either collect goods, meet someone in connection with work, or start a job, traveling from work to training venues, travel between the worker's home and the training venue does not count. Spending time training for work either at the workplace or somewhere else. This also applies to workers required to undertake training before starting a job. Stay tuned, continue watching. A person is employed as a care worker. They start work at 9:30 a.m. when they visit their first client. That appointment lasts for up an hour until 10 a.m. They then travel for 1.5 hours without any break to their second appointment, which is at 11:30 a.m. The time they spend traveling between appointments, as well as the time spent working with their clients, must be treated as working time, and they should be paid the national minimum wage for all that time. In certain situations, if you're traveling between works, you're not paid in practice. These are the rules, but it's not unknown that a scrupulous employer are breaking these rules and paying their workers only when they are working. When they're traveling between work, they are not paid, and the government doesn't do anything to regulate this obnoxious rule, which should be scrapped immediately. Stay tuned, continue watching. So a care worker has their first appointment at 9 a.m. Stay tuned, continue watching, followed by a second half-hour appointment at 9:30 a.m. to which they travel direct. They must be paid the national minimum wage from 9 a.m. to 10 a.m. They have a further appointment at noon, but returns home between 10 and 11:40 a.m. They do not have to be paid the national minimum wage for the time spent traveling from their second appointment to their home, or for the time spent traveling from their home to their third appointment. This kind of policy is from the devil, and it should not be practiced in the United Kingdom or in other countries, because we are humans. We run human societies. We are not demons or the devil, which practice obscenity in hell. And this is wrong, and it should be scrapped immediately. If they travel direct to the noon appointment from their second appointment instead of their home, in between the period when they were traveling, must be treated as working time, and they should be paid the national minimum wage for that time. If they took a rest break when they were traveling between the second and the third appointment, then that rest break would not count as working time, and they would not be entitled to the minimum wage for the rest of the break. that is also wrong and should be changed. This is the type of monstrosity. We should not allow that such evil to happen in the United Kingdom. A care worker has a 45-minute assignment at 10 a.m. followed by a half-hour assignment at 10 a.m. to which they travel direct with no break. They must be paid the national minimum wage from 10 a.m. To 11:30 a.m. After the second appointment, they have a further appointment at 3 p.m. and in the meantime, they are required to work in the office. During the time in the office, they are entitled to take a half an hour rest break. They are to be paid the national minimum wage for the time spent traveling from their second appointment to the office and for traveling to the appointment at 3 p.m. for the time in the office. They must be paid the national minimum wage for the time spent working, but the 30 minutes rest break and any payment for the rest break is excluded from the minimum wage. This is wrong and evil, and which the government has actually manufactured in hell and also trying to persecute the British people. Will stay tuned, continue watching and also listening to this type of absurdity. So working on call, we are going to look at that, and therefore when a worker is obliged to be on standby or on call on their employer's premises, so that they are available to deal with any emergencies that arise, that time spent on call may count as working time for the purposes of a claim under the limit on working hours in the working time regulations. And however, unless the worker is actually awake and working, the time spent on call may not count as working time for the purposes of calculating the minimum wage. See paragraph below. This is exactly what I'm talking about. If the worker is on a standby or on call at home, they do not have to be paid the minimum wage for this time. More about working on call and the time limit on working hours. Some of these demonic kind of policy is menacingly wrong and toxic. And in practice, the implementation only means one thing: slave labor in the United Kingdom. Stay tuned, continue watching, and thank you so much for being around, sleeping at the workplace between work duties. So when a worker is obliged to sleep on their employer's premises, so that they are available to go to deal with any emergency that arises, that time spent sleeping may count as working time for the purposes of a claim under the limit on working hours in the working time regulations. However, unless the worker is actually awake and working, the time spent sleeping will not count as working time for the purpose of calculating the minimum wage. So you see, you stay at work in vain like an idiot, and you don't get paid for that. And in a sense, you are not at home, you're not doing anything else, you are tied to situation of work and you don't get paid for it. That is a form of slavery, and it is a monstrous kind of policy. It's evidence that Britain is a very evil country because of what the government has allowed and for evil to occur in a country like Britain. If you comment below, let me know what you're thinking. Stay tuned. Thank you so much. So courts have made different decisions about what count as working to calculate whether those hours count as working hours for the minimum wage as opposed to working time limits. If the worker does not act to perform any duties during the night, they will only be entitled to the minimum wage for any hours they actually perform work. Then why in the world are they staying at work if they are not working? And if people don't stay at work unless they are there to work. Even if they are not working, because they have been asked by the employer to stay there, they are working. So the court is also doesn't know what it talks about at all. So let us look at these facilities to stay tuned, continue watching. So if the worker does not have to perform any duties during the night, they will only be entitled to the minimum wage for any hours they actually perform work. Because this is for live in Alice in Wonderland. They don't live in the real world at all. Because why should somebody stay at work unless the employer has required them to stay there? If the employer has required them to stay there, they should be paid. People don't just stay at place of work. It must be the case that they are under pressure, because in the real world, if you leave, you're going to lose your work, your job. These people are being abused by the government, by courts, and by the employer, and this must stop, because it is a form of evil which is happening in the United Kingdom. They are wrong and they are rotten. So stay tuned, continue watching. So they will not be entitled to the minimum wage for hours spent on call but sleeping. So if you are on call, should you sleep or you don't have a job, you are on call. Being on call is actually being on work. So you have judges who are actually aliens, who are not judges at all, the courts which are not really courts. These are the synagogue of demons. And they are destroying life. They are treating people like dogs in the United Kingdom, the country which has turned into a country of monstrosity. Stay tuned, continue watching. This case concerned a pub manager who was provided with free accommodation at the pub they managed, with it being a term of their employment that they slept there each night. But it was a term of their employment. If they are not sleeping there because they are homeless, they are working, they are supposed to be paid. You see, where an employee is working by being present at the employee's premises, the law should change. That's why judges may be right, because the law set by the government is rotten. So you get rotten court processes and the justice fails. Stay tuned, continue watching. Where an employee is working by being present at the employer's premises, such as a security guard, whether or not they are provided with sleeping accommodation, the court has ruled they were entitled to the minimum wage for the whole time they were on duty, whether or not they were actually performing work. That is what I'm talking about. It's not different at all with somebody whether they work in a pub or not. Where a worker has to perform in duty during the night, such as a night sleeper or at a care home, the worker was required to be at the home from 10 p.m. to 8 a.m. and was responsible for security and dealing with the emergencies during that time. They were allowed to sleep, if not carrying out any of these duties. The EAT held that the time they spent sleeping could count for the purposes of the national minimum wage. And that is how it should be. That is making sense. And if the worker is on call, but the confusion is what I'm talking about, because which is not necessary. Because these are actually cases which are the same, but they are being treated as if they are different for slight technicality created by a bad legislation by the government. If the worker is on call but does not have to regularly perform any duties during the night, in the case of two housekeepers at a shelter housing scheme, each worker's contract specified they were to be on call overnight on specified days. The Employment Appeal Tribunal ruled that they were only entitled to be paid the minimum wage for the on-call hours during which they were awake and performing work, even though all the hours they spent on call counted as working hours for the limit on the number of working hours. Where a worker is required to stay overnight at a given location ready for work the next day, known as lay overtime. Employment Support Tribunal has ruled that this lay overtime did not constitute work for the purposes of the minimum wage. You see, now what we are talking about, this is now the kind of evil we are talking about, which is designed to exploit people who are already suffering many things. You can't even count the suffering people suffer. The worker was a casual driver for the employer, driving clients going on a holiday to their point of departure. Drivers who would sometimes be asked to stay overnight in a hotel or B&B in order to be able to pick passengers in the morning. The worker could do as they wish during the layover, provided they picked the client up on time and gave the employer the telephone number of their accommodation. This was, in the tribunal's view, far removed from the situation of doctors, night watchmen, caretakers, and security guards who are on call during the night. They were not working during the layovers. They were not entitled to the minimum wage in respect of it. Output work and related output work includes piecemeal and commission work, and also stay tuned, continue watching. This is work which is paid entirely according to the number of pieces of work workers, the number of pieces the workers makes or processes, or some other measure of performance. For example, the number of transactions or tasks the workers complete. As an employer can choose between paying the employee the national minimum wage for the hours they actually work, and paying them according to the rules on rated output work. So how to calculate the average hourly rate of pay for an output worker, the number of hours actually worked in a pay reference period must be measured, and then the average pay earned per hour calculated, rather than the number of pieces made, unless the work is rated output work. This is the case even if the worker has a contract which specifies how many pieces or targets they must make, rather than the number of hours they must work. Once the average hourly rate of pay has been calculated, it is compared to the hourly rate of the national minimum wage to which the worker is entitled, to see if the worker is being paid enough. It may be possible or necessary to base the calculation on the estimated hours of work. If an output worker other than the worker doing rated output work is required to work for a certain number of hours. For example, a worker who works on the employer's premises for specified hours, their hourly pay is calculated by averaging their total pay over the number of hours worked. Once the average hourly rate of pay has been calculated, it is then compared to the hourly rate of the national minimum wage to which the worker is entitled, to see if the worker is being paid enough. Stay tuned, continue watching. If a worker's work is rated output, their employer does not pay them the national minimum wage for the hours they have actually worked in the pay reference period. Instead, the employer must pay them the national minimum wage on the basis of the hours they are treated as having worked in this period. Because of this, a client is entitled to an annual an amount of pay based on the national minimum wage, for which each piece they make or each task they do. See next paragraph for an explanation of rated output work and how to calculate the pay for that the next that the worker is entitled to for a rated output work. This is called this is an example of a calculation. Stay tuned, continue watching.